Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman, and our next guest is Johanna Matloff, partner with the Wagner Law Group. Welcome to Radio Entrepreneurs.
Thank you, Jonathan. Good morning.
Nice
Um,
to see you. I know that you practice in the areas of ERISA and employment law and a number of areas. And this morning you wanted to talk about things related to leave and accommodation
yes, I did.
and
Thank you.
some of the requirements. So you want to tell us a little bit about your practice area to start, and then if you want to jump right into the topic and tell us about what employers need to think about in the context of accommodation.
Absolutely. Thank you so much. So I am a litigation partner at the Wagner Law Group, and my focus is on disputes involving employment benefits and employment-related matters. I also do some employment counseling and some help out with some of our HR specialists here as well. So as an observation, we've been seeing more and more in the last few years issues involving claims focusing on the treatment of individuals with disabilities and pregnant workers in the workplace. And these types of issues come up not only with requests for leave, but also with requests for accommodations and complaints of discrimination. And this is a trend that the EEOC has recognized in its strategic enforcement plan for the upcoming fiscal year. And the EEOC also has prioritized a focus on discrimination against individuals with disabilities, and in particular, mental health issues, and also workers affected by pregnancy and childbirth. And some of this is because of the aftermath of the COVID-19 pandemic, where I think we all recognized that it is possible to be a little more flexible in the workplace. And not all work is being performed the same way. Work is being performed in all types of different ways, in different times and in different places. So with
Joanna,
that,
can I
yeah,
ask one question related to size of an employer? When it regards EEOC, my sense is, and maybe correct me if I'm wrong on this, but there is no difference whether you're an employer of 5 people or 500 people, whereas in certain things of employment, there are thresholds where that come into play.
that's right. And you have to be careful. There are certain, there are overlaps of state law and federal law that may come into play on certain issues, and you have to be mindful of state requirements as well, which may have different thresholds. So these are basically best practices for all employers. And,
Right.
some of them involve, well, for all employers, establishing a process and following it when it comes to requests for leave or accommodations, and that could be as simple, even if you're just a 5-person organization, designating a point of contact for leave requests and having one person sort of channel those requests and then to communicate with those in the chain of command who need to know. And also having leave request forms that document the request, the type of leave being taken, the dates that are being requested for leave, and any supporting documentation, such as like a medical certification form or a doctor's note if it's appropriate in the circumstances. And the other thing is that communication is really key in these areas, and not to make assumptions, because mental health issues may be hard to spot. And, if you may need to ask for more information and not make an assumption that, that you think that this is just something that can be brushed off and somebody grumbling about their job.
That was
The other,
something I was going to ask because,
yeah,
obviously in terms of physical ailments, very often there's something, visible, so to speak, perhaps, and not always, obviously, but something that somebody could deal with in mental health. There may not be any outward signs or anything that is, to the layperson, so to speak, or an employer that's obvious.
exactly. So like if someone comes over and asks, I've been feeling burnt out, and I need some time off, does that trigger a right to leave? Well, generally speaking, if somebody is fine, there's no job protected right because you're feeling burnt or stressed out at work. Everybody gets stressed out at work. However, you don't want to jump to conclusions because depending on the circumstances, it may be appropriate to ask for more information because stress could be a sign or a symptom of another health condition or a serious health condition, a mental health condition, which might trigger a right to leave. So it's hard. In the communication process, I think employers need to step back and just not make assumptions right off the bat, and to take each case, case by case.
Can you give us at this juncture, and I apologize if the question is very specific, but a general sense of what right to leave or what does that look like? Is it defined as a period of time depending on what the issue or the condition is, or who makes the determination of what that period of time is? Because we've all probably experienced, I need to go home. I'm feeling overwhelmed. That's okay for the afternoon. Does somebody get a right to 30 days or 60 days or, and again, in a small company where somebody may be critical and there's not, roles to backfill, what are those periods of time or how are they defined? And I know it's probably complicated because as you said, there's state and then there's federal. What does that look like?
So those are really great questions, and that they are the kinds of questions that really you should be thinking about when you're fielding these types of requests. And they come up in all different kinds of ways. If you're a large organization and you have an HR department and you have somebody like an HR generalist or an HR manager, those types of requests would get directed to that individual. But if you're a smaller organization, they may get directed right to your supervisor or perhaps a scheduler or somebody that is in charge of overseeing people coming in and out of the workplace. And it's really important that that person knows what to do when someone, like you just said, I'm feeling sick and I need to go home, or my son needs to be picked up from school because they're not feeling well. And to know, and again, one of my colleagues is going to be talking about training for employers to recognize that these types of requests need to be handled very carefully, and with the right training can be fielded correctly, requested or needed. And that may need to be supported with a medical certification form from a doctor. And that's why it's really important to carefully engage in these types of discussions with employees. So I hope that answered your question.
Yep. Thank you. I know that every case is different and circumstances are different, so it's not easy to give a general
Right.
answer. But
I mean,
I think that the good point that you're suggesting is that open communication and dialogue sort of gets you to hopefully a common ground.
exactly. And right. So and there are also like the Paid Family Medical Leave Act in Massachusetts and the Family Medical Leave Law, the federal Family Medical Leave Law, provide timeframes that you can take family leave for 12 weeks. And there are different types of maximum amounts of time that can be taken, but in each individual case, it might be different amounts depending on.
So let me ask you one specific example. If an employee is on an approved leave and a company has some sort of event going on, and maybe a mandatory training, they're bringing in an outside party to teach, teach a specific skill. Is that something that an employer can ask an employee to attend if they're on leave?
So that is a really tricky question. And sometimes, employees will want to attend training because we all know you can sit on your bed and pull out your laptop and remotely Zoom into a training that could be online even. And it's very tempting to allow an employee who's on medical leave to participate, or maybe even ask that if they wanted to participate. But really, the answer is no, because leave is intended for the employee to rest and recuperate. And even if the employee wants to attend the training, this is still not a great idea because it may suggest that the employee is feeling pressured by the employer to attend, or to feel like they might be missing out or falling behind if they don't attend the training. And so the better practice really would be to have the employee make up the training when they return from leave.
Okay, great suggestion. In follow-up question, somewhat related, but uh, when can you sort of in the whole realm of accommodation requests, when can employers push back on those requests? Are there appropriate times when an employer may look at a request and say, no, we can't
No, that doesn't
accommodate
work
it?
for me.
Yeah, I mean, I would think again, I hate to separate it large from small, but very often in small companies, there's nobody to backfill. And so, if you can justify the role, then the likelihood is it needs to be done on a regular basis.
Yes, that's a great question. So the accommodation has to be reasonable under the circumstances, and it needs to be related to the performance of the essential functions of that individual's job. And lastly, it cannot impose an undue hardship on the employer. So what's reasonable really depends on the circumstances. If you have a busy operating room or emergency room at a Boston hospital, and somebody says, "Look, I need to only work 2 hours a day, and it has to be a hard stop." That again, I can't give you black and white answer depending on the circumstances, but that might be something that would require further discussion, particularly if every single employee in that busy OR is doing everything humanly possible to save someone's life for 8 full hours. That might be a difficult situation, but again, you would need to engage in an interactive process with that employee to really see if that can work. Another example might be, for example, on a commercial construction site and a pregnant worker who needs parking. But the owner of the building says no parking, nobody can park on our property. And so having to engage in a meaningful discussion with the employee and really to have some flexibility in how to work out some of these issues is important.
So I can see where a lot of these issues may come to bear, at some point in somebody's employment life cycle. But you're also talking about situations where these accommodation requests happen prior to taking on a role, I guess. And I guess the question that comes to mind is there a duty of an employee, a prospective employee, to also make aware of their accommodation needs in advance of taking a role? Does that sort of bear like, hey, we can't accommodate that. You never told us about that. You came in the door, you knew that was a request, and now you're putting us in a difficult situation. Is
Well,
that
exactly. So the
Yeah.
interactive process is meant to have a meaningful discussion. So obviously, if the employer doesn't know that an employee has a disability or a mental health condition, then you can't really have a meaningful engagement in sort of a discussion. So you're right. The employee does need to provide some minimal information to the employer. And I would also add too, like if the employer has a reason to know that somebody might have a condition that would trigger a right under, the Americans with Disabilities Act or other laws, then they should be careful. That would require perhaps discussion with counsel on how to proceed, where the employee hasn't actually verbalized or told the employer of the condition, but the employer has sort of reason to know. So those are all very tricky questions. But you're right. In general, if an employer doesn't know that you're diagnosed with anxiety or bipolar disorder, and many people wouldn't know. So, and many people wouldn't want to share that information. Employers have to be careful not to ask for information like that. So, it is a tricky area for sure.
Yeah, well, I see that, and having been in the field for many years, I think it's only become more complicated for employers, and obviously, we all want to try and do what's in the best interest of our employees, and employ and in order to have a successful enterprise and a happy enterprise. But it is indeed a complex area, and that's why people like yourselves exist. Johanna Matloff, if people want to get in touch with you and talk more about it, and again, understanding that this is an area with a lot of nuance associated with it, to talk some of the specifics, what's the best way for them to reach you?
The best way would be to send me an email. You can reach out at J Matloff, which is my first initial and my last name, at wagnerlawgroup.com. I'm
Excellent.
always happy to chat with people on their issues. So
Excellent. And as we've discussed today, there are, as I said, a lot of nuances and a lot of specifics, and I think getting some direct guidance would certainly be helpful to prevent problems down the road.
thank
So,
you so much.
well, it's been a pleasure having you on Radio Entrepreneurs, and we'll be right back with another segment on Radio Entrepreneurs.